This Week in the Boardroom, brought to you by corporate board member and host NYSE Euronext, along with governance knowledge partners, the Center for Audit Quality, and Grant Thornton, and contributing partners, National Investor Relations Institute, and the Society of Corporate Secretaries and Governance Professionals.
Welcome to this edition of This Week in the Boardroom. I'm TK Kerstetter with Corporate Board Member, and we have an interesting show because today we're going to get board tips from our Lifetime Achievement Award winner. And it's my pleasure to welcome Peter Kreindler, who's the former Senior Vice President and General Counsel for Honeywell International. And more importantly, he was the recent recipient of Corporate Board Member's Lifetime Achievement General Counsel Award. And Peter, it's a pleasure to have you with us.
Well, thank you very much. It's a pleasure to be here, and I thank you for having me.
Well, as you know, you're in good company as one of the award winners, so we thought we'd tap some of that knowledge before you got too far away from the business perspective. And I think maybe a good place to start is I'm curious, we know that GCs are involved in all facets of the board now, whether it's committee meetings, whether it's risk or anything that's going on, the GC is involved. So when you look back from 2013 back about 10 years ago, talk about how much sort of the GC's role has changed over that 10-year period.
Well, I think it's changed significantly, and largely because of Sarbanes-Oxley, but I was very fortunate to work for Larry Bossidy, and he actually kept the General Counsel involved in everything, you know, starting back when I began in 1992. So it wasn't as big a change for me.
You know, when I had the chance to be president of a bank of a public company, and this would have been back in the 80s, you know, but which dates me a little bit. But back then, my biggest confidant was the GC, okay? And it seems to me that in the old days, that was sort of standard practice, okay? Then, you know, you have the board of directors, and I bet you if you asked any board of directors in the country, they would say that the GC has their back, okay? Well, you know that sometimes that can create an inherent conflict. Yet when you look at the environment, what it is today, while the GC has multiple responsibilities, it seems like their main responsibility is to the corporation, which the corporation then moves ahead of the CEO and the board, it seems like. But this seems to create a particular challenge for a GC. Talk a little bit about that challenge with all the responsibilities.
Well, I think, you know, the challenge differs depending upon the CEO. I think CEOs, some CEOs have their general counsel deeply involved in all aspects of the leadership of the company and are totally comfortable with the GC having a relationship with the board that is to some extent independent of the CEO's relationship. But, you know, I think since Sarbanes-Oxley and since executive compensation has become such an issue for the board and for the public that the board members tend to look to the GC more than they have in the past.
And is that when things get tough, is that the kind of situation where you might recommend that the board get some outside counsel when, you know, an issue might be conflicted, say, within a...
You know, in the almost 18 years that I was the general counsel for Allied Signal and Honeywell, I don't think I ever got outside counsel involved other than with the big deal in which we were getting a fairness opinion.
Yeah.
You know, my belief is that I needed to establish my credibility with the board and that I was fully capable of handling the company's legal matters. So I tried very hard not to involve outside counsel.
Yeah. Well, I'm not sure that your philosophy there is necessarily untypical on GCs that have a good control of their organization. So
yeah, and I think it's really a question of whether or not the board has confidence in the GC, or whether they feel they need outside counsel because they're not getting sufficiently independent advice from the GC.
Yeah. Well, certainly these last 10 years, as far as regulation goes, has been dramatic. We've seen Sarbanes, then followed by Dodd-Frank. And there's certainly a level of frustration on the board's part. Everything's meant to be transparent. Everybody's looking over their shoulder on that. When you look at that environment, is it your perception that the shareholder rights pendulum has sort of swung too far in that sense, or sort of how would you weigh that when you're sitting on the inside?
I think the SEC has gone too far in terms of shareholder proxy rights and what has to be in the proxy or not. I do think that more power has moved to the shareholders than ever was intended by corporate laws in Delaware. I don't think that's had a material impact because if a company's well run and doing well, the shareholders tend to be satisfied and will vote against, the institutional shareholders will vote against anything that they don't think really furthers their interest in terms of their investment. I think Sarbanes-Oxley did have a dramatic impact. Some of it very good and some of it not so good. I think it has put significant costs on companies that don't lead to anything good. I think the auditor's review of internal controls is basically a waste of time. I don't think it changes anything. I do think Sarbanes-Oxley, its biggest benefit was, I think, changing the quality of disclosures and leading companies to improve their processes to identify, in particular, financial issues, down in the lower echelon of the corporation. So I know at Allied Signal and Honeywell, we had a process where the CEO and chief financial officer of every business, down to the smallest business unit, had to report to the level just above them in terms of what they saw as their material financial issues. And then we had a super board, if you will, among senior officers of the corporation who reviewed all of those disclosures as they rolled up through the businesses. And I think that did make a material change in the quality of disclosure.
Yeah, we see that in our research. Sarbanes-Oxley, which was not well received initially, other than 404, which I think is what you're referring to with the intricacies of all that and the cost that was associated with digging down into 404. But you're right, the overall awareness of the board's responsibilities and the governance and the things that came, the other issues that came down in that. 5 years later, directors saw that as a very positive piece of legislation, which was interesting. Again, outside of 404.
Well, I think if you have an independent board that understands their role in the corporation, they view it as a tremendous step forward.
So what advice would you offer, let's start with the GCs, your peer group out there. What advice would you offer the GCs that you've learned over your years that would improve their relationship with the board?
I think what's most important is that you're totally candid and forthcoming with the board, and that the board feel, as I said before, that they're getting truly independent advice and judgments about the legal issues of the company. I think it's important not only for the GC, but important for the board members themselves to have an individual relationship. And I guess my advice to both GCs and board members would be for board members to have more personal contact with the officers of the company outside of the formal boardroom venue.
So you think that would be your advice to having a more effective board, or let's take it one step further. That was the advice to the relationship with the GC. What would you say to board members about, from your experience, that could make somebody have a more effective board?
I think it's important, particularly for the chairman of the board committees, to have individual contact with the officers who are really involved in the committee jurisdiction. And for example, with corporate governance, that basically fell to me, the general counsel, obviously in addition to the CEO, and for audit to the CFO. But I like the board as required by SEC rules, meets in executive session. The audit committee meets in executive session with the auditors. I think outside of the committee room and formal committee meetings, it's important for at least the chairman to have a direct relationship and open exchange with the principal responsible officer directly.
Mm-hmm. So Peter, here's the big question. So you've got global experience, you've had the opportunity for all these years working with the committees, you have a great deal of confidence and trust with your board over those years. So would you serve as a director of a public company yourself?
Absolutely. I would be interested in doing that. My experience is that most CEOs do not like lawyers on their boards.
We've heard that, but again, when you look at the experience that a lot of GCs bring, particularly from global companies, it just seems like they would be great candidates for board members going forward.
Well, I think the GC, particularly if you've served for a long time, has a unique perspective, because most issues that come before the board, and they don't have to be just serious material litigation, but all of the major decisions that come before a board have legal aspects to them. I think the law is probably an area where the CEOs have the least expertise. I mean, all CEOs are expert in human resource issues and in financial issues, but not many of them are fully versed in the law. So I think the general counsel brings a unique perspective. And because he's involved in all legal issues of the company, he understands the cross-functional impacts from legal issues and perhaps how best to solve risk issues for the corporation.
Yeah. Well, have faith. We're seeing more and more GCs take board seats, so who knows. Peter Kreindler, our Lifetime Achievement Award, thanks for joining us this morning. It's been our pleasure.
And my pleasure as well. Thank you.
And that will conclude this edition of This Week in the Boardroom. We hope you enjoyed the show. We'll be back again next week with another critical topic to make you a better board member and committee member. And we'll see you then.
Join us again next week for This Week in the Boardroom, brought to you by corporate board member and host NYSE Euronext, along with governance knowledge partners, the Center for Audit Quality and Grant Thornton, and contributing partners, National Investor Relations Institute and the Society of Corporate Secretaries and Governance Professionals.